So now formally, welcome everyone. We're so glad that you join us today. This is our first legal session of the year. We're so glad to be joined us today by Lizbeth Flores and also Victoria Sanchez from PAGLAW. They're our legal advisors here in WeInvest. My name is Barbara Haptanek, for everyone that doesn't know me. I'm the community manager and builder of this lovely community. We have Marta Cruz here joining us today also. Marta is our president. Marta, I give you your space to give a nice welcome.
Thank you. Now, I am part of the community. For the new members, I don't know if you know, we created the community in 2019, in December of 2019, together with Susana Garcia Robles. With the idea was to embrace women investors that are looking to extend the professional activity in Latin America. And we are very happy to have here 19 investors participating on this workshop that is really, really helpful for all of us. All the time that I participate in a workshop with PAGLAW, with Victoria, Lizbeth, or Juan Pablo, I learn something new. Okay, I am in the market from 2011, and I suppose that maybe I know something, but really we need to know more and more about the legal issue, because it's so important. And that's it for me, and welcome everybody. And thank you, Lizbeth and Vicky, for your permanent support.
Well,
thank you, Marta.
I would like to give the welcome to Victoria, so you can make the introduction as.
Perfect. Thank you all. Welcome. Thank you for having us. And to me, it's an honor to introduce Lizbeth Flores. She is one of the founding members of PAGLAW. She is an attorney with more than 20 years of experience. She is graduated from Harvard Law School, and she has another degree from Harvard. And she's a Mexican-American lawyer with a very interesting career. She was born in Germany. She lived for many years in Brazil. She speaks perfectly 3 languages. But the key point I wanted to highlight that she is a leading member in the community, in the venture capital community. She's a thought leader. She's a very generous mentor, and she has always been supporting the woman in the ecosystem. Without further ado, I want to introduce you to Liz, and we'll start with the presentations on funds.
Thank you, Victoria. Victoria is always very kind, and the presentation will be in English, but please feel free, if you prefer to ask questions in Spanish or Portuguese, that is absolutely fine. At PAG, we speak all 3 on a daily basis, so we're used to it. So as you know, I represent PAG Law. I'm a partner of the firm, but of course, this is not necessarily legal advice. Every case is different, but just meant to give this group an overview of some of the basic legal structure that affects funds in the United States. We also work with many Cayman Island funds, and we're starting to do a little bit of work with Ontario, Canada funds as well. It's first of all, it's a great honor to be here with this group of investors. We represent many funds at PAG Law. I'm the head of the venture capital funds practice. We form funds. We represent funds in their investment rounds with various startups and with various legal questions that come up in the life of a fund. What we've seen over the past few years is a number of existing Latin American funds forming US or Cayman structures in order to accommodate certain preferences of their investors. So we have been very active in that area. So the first question, what is a fund? So if the Investment Company Act of 1940, that is the main US regulation regulating investment funds, defines a fund as rather an investment company, as a corporation, partnership, business trust, or LLC that pools money from investors on a collective basis to invest in securities. And the investors share any profits and losses incurred by the company according to their interest in the company. Now, it's important to note, actually, the word fund is not a legal term. The US law that regulates investment companies calls them investment companies, but basically a fund is referring to an investment company. So it's a pooled investment vehicle. And as you can see, it can be formed as in many forms. It can be a corporation, it can be a partnership, it can be a business trust, it can be an LLC, or a few other types of entities. And the idea is that it invests in securities. Now, we form a lot of real estate investment funds as well. Real estate funds, so that would be a pooled interest of investors investing, in this case, in real estate. It might be considered an investment company to the extent that real estate is held by LLCs. So you should talk to your lawyer to see if a real estate fund is regulated by the Investment Company Act. The two main, and we don't have a slide reflecting this, but the two main bodies of law regulating venture capital funds in the United States, and most of the funds that we deal with, are the Investment Company Act and the Securities Act of 1933. And the important thing to know for most of the people on this call is you don't want to be registered under either of those laws. We're talking here about private funds, so not publicly traded funds. Registering under the Investment Company Act or the Securities Act is very expensive. It could get up to 6 figures in terms of legal fees and very substantial ongoing compliance costs. So, so what do we want to do? We want to make sure we are classified as a private fund. The general rule for most of the funds that we form investing in Latin America is they are called 3C1 funds under the Investment Company Act. The important thing to remember is they should be under 100 investors. That is the basic rule, or actually 99, because the general partner or manager of the fund is counted as one investor. Now, a question that we get a lot is, can you surpass the 99 investor limit by pooling several investors into an SPV? And the answer is absolutely not. Unfortunately, there's no easy way around that limitation. So if you want to stay outside of the Investment Company Act, usually in the case of most of the funds we represent, it is very important to stay under 99 investors, including investors that are ultimate owners of an SPV. If you want to surpass the 99 investors and still not registered, there is another exemption called 3C7. The threshold for the investors is higher in terms of their assets. So if you are looking at many investors, but maybe larger investors, that is another option. But for most of our clients, they are somewhat smaller investors. You want to stay under that 99 investor rule. With respect to the Securities Act of 1933, this is the law in the United States that regulates public companies. And if you don't have an exemption from the Securities Act, then you would be required to register with the SEC and give all the annual and quarterly filings that are required of registered companies. The important thing to remember here is most of the funds that we represent maintain an exemption from that registration, either under Regulation D and or Regulation S. Regulation D has the restriction that you might have heard of, that all the investors must be accredited investors. Generally speaking, this means investors with $1 million in assets. You don't count the investor's primary residence. So basically $1 million in investment assets, not counting their house, or 200,000 per year in income. That's sort of the basic guideline for an investor to be considered an accredited investor. You may also have investors that are not US persons. If they meet the qualifications for not being a US person under Regulation S, then no registration is also required. So those are the basic rules about avoiding registration in the United States, which is very costly, very prohibitive for a smaller fund. So we form many of our funds in Delaware. A big question that I always get is, why the state of Delaware? Probably most of you have never heard of Delaware outside the fact that most companies that you might have dealt with are formed in Delaware. Also, the current president of the United States, Joe Biden, is from Delaware. Other than that, Delaware isn't really relevant to most of our lives. I've never been there. I probably see no reason to be there. So why are most of the funds formed in the US formed in Delaware? The reason is because simply Delaware kind of got there first in terms of developing their corporate law and their law of legal entities in order to form companies. They got there first. They have the most developed body of corporate law. They have a special court called the Court of Chancery, which is devoted to the interpretation of corporate law. And therefore, they've just become the standard in the United States and worldwide when it comes to entities formed in the US. That's the only reason why we form in Delaware. Now, Delaware does not, contrary to popular belief, if you form in Delaware, you don't have to pay income tax in Delaware. You do have to pay what is called a franchise tax. But the important thing to remember is the Delaware franchise tax is not really a tax. It is simply an annual fee that all entities formed in Delaware must pay to the state of Delaware in order to remain formed. And this will vary according to various things, but generally it runs from $500 to $1,000. So it's not a huge amount of money. This is the amount of money that any entity formed in Delaware, whether it be a company or a partnership, a limited partnership, or an LLC, must pay to the state of Delaware to remain formed. It's called the franchise tax. Other than that, forming a company in Delaware is really rather easy. In the sense that it can be done very quickly. It can be done within a couple of days, maybe 24 hours. There's not a lot of information that must be provided to the state of Delaware. For example, the company operating agreement or the limited partnership agreement in the case of a limited partnership does not have to be submitted to the state of Delaware. Those are private documents which govern Delaware companies. Really, the information provided to the state of Delaware is quite limited, and the information that they publish on their website is quite limited. To form in Delaware, you do need to have what's called a registered agent in Delaware, and those are special companies which receive mail in Delaware. Really, all they receive is any documents relating to lawsuits. So you should never, if you form a company in Delaware, including a fund, you should never use that Delaware address as your mailing address on any correspondence, because if any mail is sent to that address, they will simply throw it away unless it has to do with a lawsuit. So that's a very limited use for the address in Delaware. Other than that, you don't have to have an office in Delaware. You never have to step foot in the state of Delaware. You would just simply pay that annual franchise tax to maintain the existence of the company. So most Delaware funds are formed either as limited partnerships or as LLCs. And what we have on the screen here is a typical organization chart, a very simple organization chart for a fund that is formed as an LP, limited partnership. The important thing to remember about limited partnership is there are two types of participants in a limited partner. You, most likely, if you are the fund manager, will have an entity, which is the general partner that you can see here on the screen. And the investors will be called limited partners. Why are they called limited partners? Because they have limited liability. Investors like this, of course, because they want to be sure that they are not going to have any liability for any lawsuits that affect the fund or any other liabilities of the fund. The general partner has exclusive 100% liability for any liabilities of the fund. That is why the general partner should be another entity. With the funds that we represent, usually the general partner is formed as an LLC, and that way the individuals who control and own the general partner don't have that liability, which could reach their personal assets. You never want an individual to be a general partner of a fund that's constituted as a limited partnership, because then if the fund gets sued, the individual's home or other personal assets would be at risk. So that's very important. Why would a company want to be formed, or an investment company want to be formed as a limited partnership rather than an LLC? Well, limited partnerships are more traditional. An LLC is relatively new. They came to existence somewhere around the 1990s. So, and LPs have been around for a while longer. But they really function for the purposes of most funds in very similar ways. The only difference is in the LP, the general partner has 100% liability, but otherwise they can be structured in a very similar way in terms of the economics. Here you see on the chart, you have an LP that is the fund. It invests directly in the underlying investments, which are usually securities of startup companies. In the case of VC funds, you have the investors, which are investors in the fund, and you have another entity, which is called an investment advisor. This is a question we get a lot. Why have an investment advisor? Well, it's the job of the general partner to really completely manage the fund. The general partner makes all decisions on behalf of the fund, but it may subcontract its power and responsibility to select and analyze investments to another company, which is called the investment advisor. Usually the investment advisor is an affiliate of the general partner, and you would have one investment advisor that acts as investment advisor for various funds. Usually the general partner will be general partner for just one fund. The investment advisor really is responsible for analyzing the investments, analyzing the portfolio. It usually employs, so for accounting purposes, it incurs costs, which are the employees, the analysts, and the office space, or any other costs of the fund manager. And in return for that, it gets paid the management fee. For some of our smaller funds, we don't have a separate investment advisor. We have a general partner, which also acts as an investment advisor. And then the general partner would get paid the management fee in that case, because they're one and the same. How does the general partner get compensated? It gets what are called performance distributions, general partner distributions, success fee, or carried interest, also known as carry. Those are all the same things. Those refer to the profits that the general partner gets once the investments are sold. And I know before the session, we did have some inquiries as to carried interest. How does it work? When is it paid? So carried interest, i.e. success fees, general partner distributions, performance distributions, those are generally paid after the fund sells one of its investments. So the management fee is a fee that is paid typically quarterly, but it can be semi-annually or annually. The management fee is paid to the investment advisor. And that is a percentage of the capital commitment usually. It can also be a percentage of assets under management, especially after the investment period, once you start to liquidate assets. But the baseline case is that the management fee, which goes to the investment advisor, is a percentage of the capital commitments. But the general partner gets the carried interest is a percentage of the proceeds. The very standard formulation is once you sell an investment, then first the investors get paid back their investment. So they will have priority to get a return of their capital first. And then the remainder is split on an 80-20 basis. That means 80% of the profits from the sale of an investment will go back to the investors, and then 20% goes to the general partner as carried interest. And that would happen periodically, usually after there is a sale of assets. It's important to remember with most of what I'm saying is just sort of the standard case. In the United States and in the Cayman Islands as well, and most jurisdictions, all these numbers, all these provisions are really provisions of the contract. These are not set in stone by law. So you can have provisions that vary, but this is really what we see in the vast majority of funds, in particular funds that are, say, smaller funds operating in Latin America. And what you might have heard of is the 2 and 20 structure. This is the standard compensation scheme for the investment manager and the general partner. The investment manager gets 2% of the capital commitments, and the general partner gets 20% of the profits from the sale of the underlying investments. So that's 2 and 20, 2% of the capital commitments to the investment advisor as the management fee, and 20% of the profits to the general partner as carried interest. And I know I've said a lot so far. Does anyone have any questions up to now? I'll just pause momentarily to see if anyone has anything.
Also, if you want, you can write them down in the chat, and afterwards in the Q&A, we can see them all together if you don't want to ask them now. Anyone?
Yes, feel free. Okay, well, moving on. So this is what a Delaware structure looks like. In the Cayman Islands, it works very similarly. The Cayman Islands entities, of course, have different names. Just like Delaware, the Cayman Islands has LPs, it has LLCs. You can form funds as either of these entities. It also has what's called exempted limited partnerships. That's an LP. Exempted means it's exempt from registration in the Cayman Islands. There, you might have heard of exempted companies and segregated portfolio companies. Those are entities that are more often used for open-ended funds. What are open-ended funds? Open-ended funds are usually mutual funds. Those are funds where an investor can put in their money and take out the money within certain guidelines, but really along the life of the fund, you have investors coming in and going out. Most of the funds that we represent, the venture capital funds in the region, are called closed-ended funds. Those are funds where the investors will put in money at one or more closings, and the money stays with the fund. The investors cannot withdraw their money through a certain period, which is the term of the fund. There will be an investment period. That's the initial few years of the fund in which capital is called. That means an investor might commit, let's say, $1 million to the fund. They don't transfer $1 million to the fund initially upon closing. They will transfer a certain portion of that money to cover initial setup costs, fees, and maybe an initial investment or two. And then as the fund during the investment period makes subsequent investments, it will call the capital. So if you commit $1 million, you might be asked to send 100,000 in initially, and then in another few weeks or months, you might be asked to send another 100,000 to fund another investment, and so on until the investment period has expired. A typical investment period might be 4 years, and that's oftentimes extendable by another 1 or 2 years at the option of the general partner. And the general partner in an LLC is called a manager. It's basically the same thing. It's the fund manager. But the money stays in until the fund liquidates. A typical term for a fund is 10 years. So you might make investments during, let's say, the first 4 years, the investment period, and then the investments stay. Sometimes the fund can make follow-on investments after the investment period is over, but usually that's the time in which the investments are allowed to grow, and you would expect to have exits. And by the end of the life of the fund, maybe the 10 years, you would hope to have had exits from most of, or at least enough of those investments to have made the fund profitable. And then you would liquidate the fund, and everyone would get their whatever money is left in the fund, and everyone will go home and use the money for other purposes. So that is a closed-ended fund. So this is a structure that we see for smaller funds. We have been seeing a lot of what we call micro VC funds, maybe funds under $10 million. It's more and more common now that funds get formed as LLCs. This is the case that I was mentioning where the manager also acts as the investment advisor, so you don't have a separate investment advisor, and then the manager would get the management fee and the performance distributions. Sometimes in an LLC, even though legally the fund manager is called manager, sometimes you hear them referred to as a GP or general partner, but it's really the same role. It's just a different name because the entity is different, but it works in a very similar way. Okay, this is what we had discussed earlier, where the general partner has unlimited liability for the debts of the fund. And then the limited partners have no role in the partnership's management. There is one exception, which is called the Limited Partner Advisory Committee, or the LPAC. You might have heard of this. So generally, under the law of limited partnerships, the limited partners have no decision-making power in the fund. But especially with limited partners that do want to take a more active role. Oftentimes we see this with multilateral investors. So development banks and entities of that nature, or corporate VCs, when they join a fund, they want to have a little bit more say than a limited partner would typically have. And the way they usually do this is through there might be certain policies that the fund is required to adopt, such as environmental sustainability policies, anti-discrimination policies, investment policies, which require them to invest certain amounts in companies that are sustainable, things of that nature. And another way which LPs can exercise some control of the fund is through an LPAC, Limited Partner Advisory Committee. And this is generally a committee formed of representatives from the most significant investors. And they may have various types of decision-making power or advisory power to the GP. Now, the GP legally has the power to make all the decisions, but they might be required to consult the LPAC with certain, when certain decisions are up. For example, a very common one is conflicts of interest. It's very common that GPs do business in investments that invoke some sort of conflict of interest. For example, a investment manager or an affiliate of the GP might manage several funds, and they might be co-investing with another fund that is managed by the same GP. Things like that, which might raise a conflict of interest, oftentimes are subject to the approval, excuse me, of the LPAC. Valuation methodologies. Generally, the general partner has a lot of leeway to determine valuation methodologies. In other words, how are they going to value the portfolio? As you all know, valuing startups is somewhat more of an art than a science. There are various ways to value startups, and it involves quite a bit of judgment. So oftentimes the limited partnership agreement will provide that the general partner must consult the LPAC if it is going to change methodologies or utilize any methodologies outside of a certain pre-approved list of methodologies. So this is one way in which a more activist limited partner might require that they have some say or some visibility into the fund. Limited nowadays in the market, in the last, since 2022, we've seen limited partners exercising much more bargaining power, much more negotiation power, simply because it is a tougher market for GPs to raise money. So it's harder to get LP investments. Therefore, LPs have been requiring more in terms of participation on LPACs, certain policies that they want GPs to cover. and things of that nature. Ability to kick out the GP with a certain vote of the limited partners, things of that nature. So we're seeing a trend towards more power exercised by the limited partners. If one is a limited partner, one shouldn't take for granted that what was maybe normal in the market a few years ago would be normal today. There are always changes and evolution in the market. I would ask around to other people who are investing. Your lawyer should know where the market is going at any particular point in time. One question that we get a lot and that we've seen LPs requesting a lot lately is called clawback. You might have heard of this. It's kind of a scary term, right? Clawback. What does that mean? A GP clawback means that over the life of the fund, if the general partner gets carried interest that is over what it would have gotten in the aggregate, given the profits of the fund, then the limited partners may claw back any excess. So here's an example. Let's say you have a carried interest of 20%. But remember, the carried interest is paid generally on a per investment basis. And you might have heard of the European waterfall or the American waterfall. The difference in the European and the American waterfall is when the investors get their capital back. But with either waterfall, somewhat less common in the European waterfall, GP gets its carried interest on a per investment basis over time. But it may be that you have a very large investment one year and they get a very large carried interest of 20%. And then you have several other investments failing over subsequent years where they would get no carried interest. And mathematically, it might work out that over the life of the fund, the general partner gets more than 20% over the capital invested. In that case, the clawback would come into effect. And we weren't seeing as much demand for the clawback clauses when things were booming in 2020 and 2021. We have seen a lot more demand for those clauses in the last year. Another clause which you should be aware of if you are an LP or a GP, but which affects the LPs or might affect the LPs, is called the LP give back. It's sometimes also called the LP clawback. This is the LP give back is a protection for the general partner. And it's very important for LPs to be aware of this when you review fund documents. The way that works is, let's say the general partner suffers some certain liabilities, they get sued, for example, and they have to pay money in a lawsuit or some other contingency, and there is not enough money of the GP. In cases where there is an LP give back, the LPs may be required to give back some of their distributions. Obviously, if you've already spent the money, this can be very bad. It can be very disruptive. So it's something to be aware of. Why would a GP get sued? The most common case where a GP gets sued might be where they act on the board of one of the startup companies. They have a representative on the board of one of the startup companies, let's say, and the board is found to have done some misdeed. Then the fund itself might get sued. Now, of course, funds that are well advised and have good lawyers will always make sure they have some indemnification from those companies, or directors and officers insurance to cover those losses. But crazy things happen sometimes, and maybe a GP might be found liable in that case. If there is an LP give back, the LPs might have to give back some of their distributions. So something to be aware of when you read fund documents. So what do the fund documents look like? So in the case of a Delaware LP, you would have a partnership agreement, also called limited partnership agreement, also called LPA. This is the agreement that sets forth all the economic terms, which I've discussed, all the rights of the GP, the rights of the LPs. Very important to have your lawyer review that. That is the most important document governing a Delaware LP. There's also a subscription agreement. That is the agreement signed with the individual investors, where the investors will represent, in the case of a Reg D fund, they are accredited investors, and they will put in their information and various other representations that they're required to make to show that they are qualified to invest in the fund. And so that is what is signed with the individual investors. Each investor signs its own subscription agreement, but they should be all the same. And then the PPM. PPM refers to private placement memorandum. It could also be called an offering memorandum. Most funds, we would normally advise to use a PPM. This is a document which summarizes the basic terms of the fund. So it will summarize the important terms of the partnership agreement. It will contain the investment thesis of the fund. It might have biographies of the key persons at the fund manager level. It is supposed to be written in pretty understandable language so that investors who are not lawyers can review it and understand basically how the fund works. Now, sometimes in smaller funds where there are very few investors and the investors are all known immediately to the fund manager, there might not be a PPM. But the normal case is that there is a PPM. In the PPM, you'll also see a section called risk factors, factores de riesgo, and those are a very scary language that says you might lose 100% of your investment. Venture capital investing is risky. The fund has not been registered under the securities laws. Our clients always get scared when they see those risk factors. Those risk factors are really to protect the general partner. So if the general partner ends up losing all the money, the investments go south and they are not profitable, then and it gets sued by the investors, they can always show that they presented these warnings in the PPM. But it's well known to everyone that venture capital investing is risky, but most people don't like to be reminded of that. But it is the case. Most fund managers will tell you, oh, they're going to multiply your money. Well, they shouldn't legally be telling you that because nobody knows what's going to happen in the future. The fact is you could lose your money, but obviously if it's a good fund manager and the market goes well, then investors will make some good returns. And in an LLC, the documents are very similar. Really, the only difference is instead of a partnership agreement, you will see an operating agreement or an LLC agreement. Those are all the same thing, just in the case of an LLC. Oh, and one other point that I mentioned was key persons. This is also just something that comes to mind as something that's been requested quite a bit by LPs, is they want some sort of guarantee that certain key persons will remain with the fund manager. So you might have one or two or three individuals who you are really entrusting with your money, and you say, well, if this individual leaves, then I want to have a chance to either dissolve the fund or withdraw my money. That is something that we are seeing a lot of investors asking for lately. So that is just to be aware of for these smaller funds. Oftentimes the key persons are very important to the investor's investment decision, and investors might ask to be able to get their money back or maybe get their money back upon a vote of the majority of the investors if the key persons leave. Now, another important point with funds is service providers. So service providers are very important to the fund, not only the lawyers, but every fund should have a CPA. Fund accounting is very complex and specialized, so it should have an accountant that will be involved from the very beginning to advise with respect to the tax structure, and the CPA, which is Certified Public Accountant in the United States, will provide accounting services and do the annual tax filings. Now, if the investors or the GP beneficial owners are located located in outside the US, which they probably will, in the case of most people on this call, you should talk to your local advisors as well, because the local advisors will be able to tell you how any proceeds you receive from the fund will be taxed in your home country. So in addition to the US CPA, it is very important to have qualified accountants and tax advisors in the country where the beneficial owners are located. And then there is another entity which most people are not familiar with the first time around, called the fund administrator. This is a third-party entity which does a lot of the things that we might think of as back office, but they really are fundamental to the compliance of the fund. They will handle the onboarding of investors, the KYC of investors. Nowadays, there are a lot of platforms which are used by or affiliated with fund administrators. And I think that's where we're moving in the market, where subscription agreements will be online. And rather than filling out a piece of paper, the investors will put their information into a platform. That is often in conjunction with the fund administrator's work. The fund administrator usually is the one that reviews the subscription agreements to make sure that all of the investors are compliant with regulations. They know your client on the investors, and they will do the net asset valuation value calculations as well. That's actually not the CPA's job, that's the fund administrator's job. So it's very important that you have both, in addition to qualified lawyers, of course. That's how you get your team together to start the fund. So I see we have a little bit of time left. I think that is a good place to stop. And I hope that was helpful, and I hope there are lots of questions.
Thank you very much, Lizbeth. That was amazing. I thought it was super interesting. I think I got a lot of new information. I couldn't stop writing. We can open up for questions. If you want, you can put the little hand up and we can unmute you, or you can write it down and we can read it. Anyone?
Y las preguntas pueden ser en español, pueden ser en portugués.
But I'm gonna stop recording